Hello, so for today, we'll be talking about the right to privacy. This is one of the limits to freedom of expression, of speech, of the press, and even the right to information. You can always invoke privacy against all these other rights. Now, how do we protect the right to privacy? Essentially, the right to privacy, gives a person the right to determine what, how, and how much, to whom, and when information about himself shall be disclosed. Essentially, you can also call the right to privacy the right to be let alone. In the Philippines, the landmark case for privacy is Morpe versus Mutuk, 1968. In the Supreme Court, in the Supreme Court's decision, they cited or they referred to an article, to a column of Carmen Guerrero Nakpil, who says that, she points out, privacy has no precise translation or word in Filipino or any of the local languages. Well, however, later, Justice Irene Cortez writes a treatise on privacy and says that anyhow, the concept has been in the Philippines for so long. During the pre-colonial era, there is um, proof that early Filipinos had laws for those who passed by the chief while he was bathing in the river. And that these laws decreed slavery. The Code of Kalansha, which is contested and actually at this point debunked, also stated that any person who entered without permission the house of the Maharlika was punished with death. So the concept was there. And essentially, the right of privacy has foundations in natural law. It is, recognized intuitively wherever you go. You feel that you are entitled to it. Now, just to visualize the concept of privacy, let's look at circles of intimacy, all right? So this is you. You and your secrets, your hopes, your memories, everything about you. Let's look at the second circle, which would be around you, representing probably one, two other persons who could be your spouse, your parent, your roommate, or loved one, no? Where you share private information and this is reciprocal. Pareho kayong nagkakwento tungkol sa isa't isa. And the relationship is clearly based on trust. Outward, we can have this third circle, and this would represent others with whom you are very close, probably family or friends, your lawyer, your confessor. Uh, Here, the basis is still, yes, of trust, but the communication in this circle is probably one way. So, ikaw yung nagkikwento. And you have no complete control over the other person. Compared to those when you're in the second circle, you would feel less betrayed than if the persons in your second circle told your secrets, no? And so as the circles of intimacy progress away from the innermost circle, from you in the middle, what you reveal about yourself becomes progressively more public and less intimate. And you progressively lose more control over the information about you. Now, let's talk about threats. Who could threaten your privacy? We'll talk about this later. Government, of course. There's business and also other persons with their personal interests. Okay, and with that, let's go to the constitutional framework of the right to privacy. Here we have still Section 2 of Article 3 of the Constitution. So we're still with the Bill of Rights. We've talked about this so many times, and we have to emphasize again that the people have the right to be secure in their persons, houses, papers, and effects against, again, unreasonable searches and seizures. Okay? Unreasonable searches and seizures. Now, it is section 3 of the same article, which clearly provides that the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise, as prescribed by law. The second part of this section is called the, fruit of the poisonous tree doctrine. This is the exclusionary rule. Okay. Essentially, if persons or remember, Article 3 can be or should be invoked against the state. If law enforcement officers were able to obtain information, communications, evidence against you or against the person in violation of the privacy laws, in violation of the earlier provision on unreasonable searches and seizures, if the evidence is contrary to law, is taken contrary to law, then it cannot be used as evidence against you. It will be inadmissible in court. Yes, it may exist, but the judge cannot take notice or cannot consider it in his or her decision. Okay? Dapat hindi niya pansinin. Okay? Siyempre, ibang bagay na kapag napunta na tayo sa social media at saka sa public arena. Pero this is clearly a matter for the courts. The exclusionary rule and the fruit of the poisonous tree. On a side note, bakit fruit of the poisonous tree? Kasi if you look at the poison tree, if the tree is poison, then the fruit would also be poison. Okay? So therefore, the fruit of the poisonous tree. If the search or the seizure is illegal, or the taking of the item is illegal, then therefore, you cannot have any use, or the product will still be poison. That's how you can imagine it. Now, the other laws that provide for privacy in their text would be the Civil Code. Clearly, Article 26. So in Article 26, it identifies, enumerates acts which will be a violation of privacy, a violation of the dignity, personality, peace of mind of persons. Para sa mga marites, bawal makialam sa bahay ng iba. Bawal makialam sa buhay ng iba, sa private life or family relations of another. Bawal manchismis para mapalayo ang loob ng isang tao sa iba pang tao. Bawal mang-humiliate o mang-inis ng isang tao dahil sa sitwasyon nila sa buhay. However, again, we are talking about the Civil Code. Kung bawal sa Civil Code, ang makukuha mo lang ay danyos. Ang resulta lang ay danyos, hindi ito criminal action at this point, if you're going to invoke this. So, pera lang ang makukuha mo. Well, pwede na rin. Also in the Civil Code is Article 723, which clearly specifies that letters and other private communications in writing are owned by the person to whom they are addressed and delivered. So, kailangang ma-deliver yung mga sulat. Kung hindi, edi kung sino yung writer. Kaya, yung consent na kukunin mo kung ipapublish mo ito or ipagkakalat mo would be from the writer, ito pang nakalagay, or his heirs. Meaning kapag namatay ka na, pero may mga love letter ka pang nabubuhay o naiwan, pwedeng payagan ng iyong kapamilya na i-publish din yan. Also, the court can order that these love letters o kanong mga itinatago mo be disseminated if the public good or the interest of justice so requires. I would suppose dito pumasok kung bakit ang mga love letter ni Jose Rizal sa kanyang mga chika babes ay kinailangan i-publish eventually. Now, let's look at the more particular law on data privacy. So, clearly, Data Privacy Act, Republic Act number 10173. It has its corresponding implementing rules and regulations. Essentially, the Data Privacy Act protects all forms of information that are personal, private man yan or privileged. And this is important. It covers all persons. Tao man na natural or korporasyon, person created by law. Korporasyon, asosasyon, organization, or any gathering of persons na formal. And there is a particular emphasis with regard to juridical entity as to their duties when they are involved in the processing of protected information. We'll have a little bit more on that when we discuss more about the National Privacy Commission. But now let's have a short video about this law, the Data Privacy Act. Okay. So now we have another law. Let's just run through the laws, okay? This law is the Anti-Photo and Video Voyeurism Act, Republic Act number 9995. So it prohibits the unconsented taking of a photo or video of a person or a group of persons, okay, who are clearly engaged in a sexual act or any similar activity. In short, live show, masturbation, and any activity of such nature. So also the capturing of the imaging of the private area of a person. So kahit walang ginagawa. So picture lang. When especially there is a reasonable expectation of privacy, okay? When you think of reasonable expectation of privacy, then visually, if you go into a room there you have a reasonable expectation of privacy. Pero kung naghubad ka sa kalye, sa gitna ng EDSA, then you would have no expectation of privacy there, right? In any case, this Anti-Photo and Video Voyeurism Act makes it illegal that these videos, these photos are copied, sold, distributed, published, broadcast, pinadala man sa over the internet or any other network. Okay, so initially it was aimed at protecting those who had sex scandals. And as an offshoot of one of our earlier discussions, actually our midterm exams, this act came about partly because of the Hayden Ko and Katrina Halili scandal. Okay. May panahon talagang nauso itong mga sex scandal na to eh. Okay, another law that we need to think about. This is an intrusion, okay, into the right to privacy. Republic Act 4200. This law became prominent because of the alleged wiretapping of the conversation between a COMELEC official and GMA. Okay. Wiretapping is what it is. You tap the wire. Okay? So, dati kasi, yung landline, literally may wire. So, ngayon, wala na kayong nakikitang mga kable. Pero, in essence, it would remain the same. So, when you tap the wire, you try to intercept illegally or without the consent or without the knowledge of the persons speaking on each end of the line, you're intercepting their communication. So, today, even if the means are different, in digital communications, anything that intercepts or takes or gets or records the conversation of any other party without their permission and without their knowledge would be considered wiretapping. Of course, there are nuances, pero it would depend on the technology involved. But let's hear about, okay, sorry. So here, it would be clearly unlawful for any person to knowingly possess as well. So to have these tape records or any other recording or any copies of those, if prohibited by law, and then you cannot replay it for any other person. So you cannot tell others what what was in the record, etc. Of course, in practice, this hasn't been the case. I'm sure many of you would know about still these recordings taken pero still on the internet, which is why I can show you today, or I can let you hear the recording of allegedly PGMA and the COMELEC official Virgilio Garciliano. This is the Hello Garci scandal. Let's have this.
Hello. Hello, Garci. Ma'am. Nausap na kayo ni Adalos. Ma'am. Okay. Mamamasyal muna daw ako sa Mindanao. Kaya nga kung ano man ang mga problema natin, tawagan lang ho ninyo. May problema sa South UP. Pero lokal. Kasi iba-iba raw pinag-claim ng Commonwealth doon. Sino ba atin doon? Naku, ang importante na hindi madama yung sa taas. Hindi ho. Ako ang may hawak nun. Kasi ang issue doon, sabi ng corruption, dahil nila sa nila yung recount, pero sabi naman ng issue doon, dapat doon na lang sa munisipyo. Doon na lang ho. Okay na yun. Ako may hawak niyan. Sige. So hindi na-access ko yun sa taas, ha? Hindi ho. Kasi sabi nga nila, kung may exclusive, baka susunod na ito, bumagatan nga naman daw doon, ha? Hindi ho. Nasa akin ho yan. Okay. Sige, guys. Okay. Thank you. Sige po.
Okay, so these were a series of recordings or series of tapes. Let's listen to another one.
Okay, mas mataas po siya pero mag-compensate po sa lanaw yun. So will I still lead by more than 1M? Well, if it's young age, that's advantage, ma'am. Parang ganon din ang lalabas. It will not be less than 1M? Pipilitin mo natin niya, pero as of the other day, it's 982. Kaya nga eh. And then, if we can get more in Lanao. Hindi mo matapos? Hindi pa ho. Mayroon pang darating na 7 municipality. Okay. Sige po. Okay.
So in Garciliano versus House of Representatives, this was precisely the issue. So these tapes were allegedly in relation to the May 2004 elections where Arroyo supposedly, as we see it now, won the elections. Now, because these tapes surfaced, the Senate, as usual, called an investigation. Okay, so during the investigation, these tapes were played, and of course, ipit dito yung presidente and at that time, COMELEC Commissioner si Garci. And during the investigation, while the investigation was ongoing, Garci went to the Supreme Court first to disallow the Senate to continue with the playing of the tapes, and second, essentially, to continue with the legislative inquiry. Okay. So on those 2 points, the Supreme Court held that first, as to the striking of the record, the tapes, it cannot be granted because they were already played in Congress, highly publicized. Therefore, kahit pa sabihin na nating pagbabawalan ng Supreme Court yung pag-play nito ulit or further onwards, wala na control. So, itong tawag natin sa mga ganong sitwasyon na wala ka nang magawa. Kung wala na eh, nandun na sa public, moot and academic. Okay? Kahit pa pag-usapan, it will be just an academic discussion. On the second point of the petition, ang sabi ay, can the Senate continue with the investigation? They titira nila to on a technicality. They said that the Senate had rules on the conduct of an investigation, but it was not published. Remember, Tanyada versus Tuvera? Similar to that, analogously, rules with regard to these kinds of investigations should be published, and the Supreme Court ruled in favor of Garci and said that the Senate cannot be allowed to continue unless its rules of procedures are published. And so the Senate published its rules, which allows them currently to proceed with these kinds of investigations. All right. Let's go to a more updated law. This is the Anti-Terror Law or Republic Act number 11479. Just last week, the law was upheld as constitutional. Okay, the term that the Supreme Court uses is not unconstitutional. So, magka-cancel yung not tsaka un. So, bakit hindi nilang sinasabi ng Supreme Court, well, this law is constitutional. Okay. On a side note, the premise is this: all laws, all actions of government are presumed constitutional. Okay? And any person who goes to court will have to allege that it is unconstitutional. Which is why the Supreme Court will have to say that it is not unconstitutional. Okay? That's why you will never hear the Supreme Court outrightly say that this person, the acts of this person, this law is constitutional because it's presumed. Okay? May presumption of regularity of duty ang nasa gobyerno. Which is why it's really a challenge. It's really great privilege, no, when you're in government or part of any governmental functions. All right. The section that is particularly of interest to us in this topic would be section 16. If you remember, just to throw back, we had a discussion on incitement as one of the crimes punished by under the anti-terror law. In this topic, we will be talking about Section 16, which would be the surveillance of suspects and interception and recording of communications. Okay? So it refers, the ATA also refers to the anti-wiretapping law. Pero dito, mas expansive na. Okay? Essentially, it's the same, no? So it allows law enforcement agent or any military personnel, o medyo dumami na kasi clearly military personnel, no? To wiretap. Okay? Conversations, communications, etc. Pero ito, medyo updated na. So, just last year, last year lang tong batas na to. So, babasahin nyo, mechanical, there is a very, very curious phrase. So, the collection, recording, surveying, reading, etc., intercepting can be done with the use of any kind of or type of electronic, mechanical, etc., or a equipment or device or technology now known or may hereafter be known to science. So, kung ano pa man ang maimbento in the future na communications technology, pwedeng gamitin in the implementation of the anti-terror law. But bago kayo manginig at matakot, the anti-terror law is supposed to target those who are committing, planning to commit, facilitating the commission of, etc., terrorism. Kaya lang, ibalik ko rin ulit, ang problema, it's a government which can define what terrorism is. So, if it says what you're doing is terrorism, then baka pumasok dito sa anti-terror law. Under the anti-terrorism law as well, this same section, there's a second part of this section 16. There is called, this is the obtention of your records from any TSP or ISP. So if you're a suspected, charged, or convicted, sabihin na natin na terrorist, your records from Globe, Smart, PLDT, etc. can be requested by the government. So, these data would include call and text data records, sinong tinext mo, anong oras mo tinext, anong oras mo tinawagan, content, alright, and even metadata. Okay, the difference between content and metadata would be, if I send you a photo, okay, if I send you a photo, you will see the photo. That's the content. Pero if you click yung mga three dots or if you look at the other details of the photo, you will know what camera I used to take that photo, when I took that photo, file size, etc. So that's the metadata, diba, of any person. Oh, sorry, of any information of any content. So that can also be taken or requested by the military or law enforcement personnel. This kind of information or this kind of request is unheard of in previous laws kasi this is clearly a violation of your right to privacy. But the government says that they have authority or they have a compelling reason to request it or to receive this information. Sabi nila, all-encompassing naman yung sa anti-terrorism law. Oops, sorry. Ito pala yung slide. Okay? All right, let's move now to some of the cases that we have on privacy. Okay, the first case that we have would be uh, Griswold versus Connecticut. In Griswold versus Connecticut, the U.S. Supreme Court ruled that a state's ban on the use of contraceptives violated the right to marital privacy. Okay? In Connecticut, then, there was a law that criminalized the encouragement or the use of birth control. So, ang tagalan nito, 1879. Okay? So, sabi doon, they will be fined about $40 and in prison not less than 60 days. This was challenged by the executive director of Planned Parenthood League of Connecticut. So parang NGO nila or organization and a doctor. Apparently, they were supplying or um, educating, okay, people on contraception. So they were charged for accessories to providing illegal contraception. Initially, they were fined, so they were found guilty. They went up to the court, tapos sabi, to the Court of Connecticut, tapos sabi doon, okay, the law violated the US Constitution, pero nung umakyat pa ulit sila, um, na-uphold yung conviction. So anyway, they went up to the Supreme Court where for the first time, the Supreme Court clearly ruled that there is a right to marital privacy. And essentially, that this right is protected under the First Amendment, which is on free speech, the Third Amendment. Okay, this is the prohibition on the forced quartering of troops. Basta, yung parang uh, parang isusona, ilalagay sa isang lugar. Also, the Fourth Amendment, which is their freedom from searches and seizures. Fifth Amendment, freedom from self-incrimination. And Ninth Amendment, other rights. And there's a 14th Amendment as well that they refer to. Pero all these amendments created a general, quote-unquote, right to privacy. So, from what it appears, katulad natin, wala rin sa batas nila clearly yung right to privacy at that point, no? In the Philippines, the right to privacy was only recognized in the 1935 Constitution. In the US as well, in 1986, they had Bowers versus Hardwick, which was a landmark decision of the US Supreme Court then, no? Which upheld the constitutionality of a state, this was in Georgia, of a state law on sodomy. It criminalized oral and anal sex in private, in between consenting adults with respect to homosexual sodomy. Okay? Although the law did not differentiate really between homosexual sodomy and heterosexual sodomy. Essentially, it was a sodomy law. Okay? Nevertheless, this case was overturned by Lawrence versus Texas and 2003. Likewise, a landmark decision by the US Supreme Court. So, clearly dito na nilagay nila. Sanctions of criminal punishment for those who commit sodomy are unconstitutional. On a side note also, in the same case, Lawrence also invalidated age of consent laws that differed on sexual orientation. Essentially, actually, what Lawrence did was ask have the states review its laws. Okay, in Kansas, the Supreme Court ordered the state to review its Romeo and Juliet law. Okay, it reduces the punishment for a teenager under 18 years of age who has consensual sexual relations with a minor, no more than 4 years below, so no more than 16 years old, 16 and 18, but explicitly excludes same-sex conduct from the sentence reduction. Nung 2004, yung Kansas upheld the law as is. Sabi nila, okay lang yon kahit may distinction. But the Kansas Supreme Court said, no, there should be no distinction dun sa same-sex conduct or heterosexual conduct. These cases, landmark cases, no, are similar to Roe versus Wade, which is our landmark case in the US on abortion. So, the case began with Jane Roe, okay? Roe is not the name of a particular person, it's a pseudonym. So, Jane Roe um, challenged Henry Wade, who was the district attorney of Dallas County in Texas, okay? Roe asserted that she had an absolute right to terminate pregnancy in any way and at any time. Okay? However, so in the decision, the court said this right, okay, so the woman may have a fundamental right to privacy. It protects the pregnant woman's choice whether to have an abortion or not. But the Supreme Court said, however, this right is balanced against the government's interests in protecting women's health and protecting the quote unquote the potentiality of human life. Okay. So the Supreme Court in this case said that the due process clause of the 14th Amendment, okay, it protects against state action the right to privacy and the woman's right to choose. However, the state has legitimate interests, okay? And the relative weight of these interests, of course, varies over the course of pregnancy. So, hindi pare-pareho at every stage of pregnancy. Okay, ito na. Una, first trimester of pregnancy, ang state may not regulate the abortion decision. Walang kinalaman dyan. Only the woman and the physician can make a decision. Second trimester, the state may impose regulations on abortion that are reasonably related to maternal health. In the third trimester, since the fetus already reaches the point of viability, so mukhang tao na ito, kumbaga, here the state may regulate abortions or prohibit them entirely, so long as the laws contain exceptions for cases when abortion is necessary to save the life or health of the mother. Nevertheless, this case all in recognizes the right to privacy and the right to choose of a pregnant woman. In Bolger versus Young's Drug Products Corporation, so here the Supreme Court, US, declared unconstitutional a federal, so national regulation prohibiting the mailing of unsolicited advertisements for contraceptives. So ito, advertisements na naman. So commercial speech essentially. In this case, the court seems to demonstrate a willingness to invoke the First Amendment, okay, freedom of speech, to limit yung regulation ng US Post ng content. Okay, so US Post ang ano nito, ang it's because since forever, the US Postal Service has regulated content of mails. Remember, we've had cases of obscenity, di ba? Yung minimail nila yung kanilang mga advertisement for obscene materials, okay? So, the Post regulates the content to protect the public from objectionable materials. In this case, the court, both the Federal District Court and the Supreme Court, look at this as commercial speech, okay, referring to Central Hudson Gas and Electric, you know. So they said that the statute, the law that bans it, was more extensive than necessary to serve the government's interests, and therefore the regulation violated the First Amendment. So basically, what the court did, was look at the characteristics of the pamphlet. So una, tiningnan niya, ano ba yung content? yung advertisement mismo, ano yung reference to a specific product, and then third, commercial speech to eh. So, ano yung economic motivation? Okay? Bottom line, sinabi nila, it seems like these informational pamphlets are actually just commercial speech and, in a sense, protected. Okay, so far we've had private choices with impact or with public consequences. Okay? Bakit ganun? Eh, dapat pansarili kong desisyon to. The case that we will have next is about just simply information. So it's not a choice. It's information that you're already given to the government. Okay? So we're talking about KMU versus Director General. Okay? In this case, we're talking about a unified ID system as proposed by President Arroyo. Okay? She ordered various government agencies, GOCCs, etc., to collate all information and have a uniform ID. Okay, this was the precursor of the national ID system in a sense, no? Uniform ID for all government agencies. Okay, siya lang may sabi noon. Kilusang Mayo 1, which is a trade union organization, and many others assailed this executive order for being excessive, no? Hindi ito trabaho ng executive, dapat legislative yung gumagawa nito. And therefore, the executive usurped the power of the legislative. And also, second point is that it infringes their citizens' right to privacy. Ngayon, with those two questions, ano ang sagot? First, did they uh, interfere or excessive na ba yung powers na in-exercise ni Arroyo? The court looked at the history of issuing ID cards by these agencies. So specifically, we have GSIS, SSS, LTO, PhilHealth. So they have been issuing ID cards. Okay? Wala namang reklamo daw yung mga tao noon na kunin yung information nila for the ID cards. Okay? So sabi nila, okay lang if you get all these. Especially that this information are already in the systems of these government entities. And thus, the issuance of your ID cards would be pursuant to regular functions under existing laws. Okay? So, sabi nila, yung EO 420 does not grant these government entities any additional power that they do not already possess under the existing laws. And what would be the data collected and recorded? Okay, so specify nila. So your name, your home address, your sex, your photo, signature, date of birth, place of birth, marital status, names of parents, height, weight, two index fingers and two thumb marks. Any prominent distinguishing features like moles or others. And lastly, tax identification number or TIN. So essentially, in this case, the Supreme Court said that a unified ID system for all entities concerned was purely an administrative power and hindi kailangan ng exercise ng legislative power. And so, which is why I will show you that kind of ID. I have this UMID, the Unified Multipurpose ID, which is valid as of now, which covers my SSS, my PhilHealth, my TIN. Okay, so yung UMID. This is different from the national ID, which needed legislation. So right now, I think, under process yung national ID system or information taking. So that's another step altogether. Okay, so we've talked about information that should be private. How about things that we receive? All right? Or that as in literally things that we receive or take out or possess. Now, in the case of the Sini versus Executive Secretary, this is a very, very long case, okay? There's an extensive discussion of privacy, but let's just look at the discussion on spam, okay? Uh, Things that you receive in your electronic mail and of that sort. This was specifically Section 4C3. Kasi in the cybercrime law, it was illegal to transmit unsolicited commercial electronic communication. So, spam that seek to advertise, sell, or offer for sale of products and services unless the recipient affirmatively consents. Ang sabi ng gobyerno, yung unsolicited commercial communication amounts to both nuisance and trespass because they intend to interfere with the enjoyment of using online services. Tapos, this kind of information or this communication, they enter the recipient's domain without permission. Again, here the court applied the definition or the concept of commercial speech. And although to some extent it is commercial speech, it does not receive the same level of protection as other constitutionally guaranteed forms of expression. And so still, sabi ng Supreme Court, prohibiting the transmission of unsolicited communications would deny a person the right to read his emails, even unsolicited commercial ads addressed to him. Gets? Kaya, naging unconstitutional yung Section 4.3 C3. Okay? Essentially, in this case, this is why we receive spam as of now. Because not receiving it would be an invasion of our privacy dahil who would read and who would know that these documents are spam. Now, I know there is a pending issue right now about smishing and phishing, pero that is more an issue of private data leakage. Okay, a little bit later kung yung violation siya ng Data Privacy Act kasi lumabas na yung email mo or yung cellphone number mo dahil nga recently, at yung sinasabi nila, recently we've implemented the health declaration protocols which allows other persons to see or to record our emails as well. Okay, just a little bit about People versus Marty. Okay, it's not actually a privacy case, but I put this in as a reminder that I've discussed this, that the Bill of Rights is taken against the state, diba? So the Bill of Rights, the entire Constitution, it's to be taken as against the awesome powers of the state. Yung third parties are not included. However, in the case of People versus Marty, where a person went through a private courier, tapos yung security guard ng private courier opened the his items, no? So, parang LBC, ganyan. Binuksan yung item, tapos nakita nilang may kontrabando. In that case, it was upheld that the search, quote-unquote, and the seizure by a private entity was valid. Okay? Because private persons cannot be held up to the standards of Article 3 of the Constitution. So, mag-ingat kayo kung security guard ang kukuha because a security guard is not a law enforcement officer. Okay? Okay. Let's have next a few points about the right to privacy. Before we go specifically into privileges, I'd like to recall our previous discussion on special laws with regard to privacy. At the last session, we said that some special laws apply to rape victims, child and family cases, those afflicted with AIDS and COVID. All of them have the right to privacy. Now, these provisions or these topics that we will talk about now will be about privileges or in the context of the rules on evidence. So, hindi mo rin magagamit na ebidensya. First, you have marital privilege. Conversations between husband and wife cannot be used against each other except kung nagkasakitan sila, nagkapatayan, nagkaroon ng criminal action yung one against the other. Also, filial privilege. So, yung kamag-anak mo, direct descendants ha. So, pinsan, labas yan. Tita, labas yan. Direct descendants would be lolo, nanay, tatay, ikaw, anak mo, apo mo. So, direct, one line. Walang gilid-gilid. Filial privilege says that you cannot be compelled to testify against persons within your direct line. There are other privileges that apply to, remember the circles of privacy, of intimacy. Okay, so yan yung first circle natin. So within your second sphere or second circle. Onward to the third sphere, we said that there would be persons in a position of trust, like your lawyer, your priest, your physician. Okay? Whatever you say to them or whatever they know of you, so it could be your medical results, medical abstracts, medical condition to reflect whatever is wrong with you or what is not wrong with you, no? So yung sa physician, uh, that's also covered. Likewise to priests whom you shared your secrets. Laging question ito sa bar exam, but of course will not have this case in our exam. Hindi pala sa bar exam, sa klase, no? Sobrang luma na kasi yung magsusumbong ka or magko-confess ka sa pare na meron kang pinatay, anong gagawin mo? So, is it covered by the penitent priest privilege? But again, as to all three, okay? Ito kasi medyo uh, may ano ba daw, kolatilya. Pag pumayag naman yung both parties, edi okay lang. Pero otherwise, entirely privileged. Now, as to commercial or yung sa trabaho mo na, okay, medyo labas na to dun sa spheres of trust mo. Trade secrets, so if you're employed in a corporation, you cannot disclose information that would be to the disadvantage of the corporation where you came from kung lumabas ka na. Likewise, public officer who used to work or who used to be a public officer cannot be examined as to what he did as a government official. Okay, so now we talk about particular concepts or particular topics, and one of them would be the right to be forgotten. Earlier, we said that the right to privacy involves the right to be let alone or left alone. Let's talk about Google Spain versus AEPD and Costeja Gonzalez. Okay, so Mario Costeja Gonzalez had financial difficulties. And so, to solve them, nagbenta siya ng property niya. So, he put some properties up for auction. Of course, kinover naman sa newspaper and it went online. Matagal na yon. Kaya nung nabenta na, umokay na, moving on na tong si Mr. Gonzales. Pero ito namang si Mr. Gonzales, naisip niya, sige nga, i-google ko yung pangalan ko. And when he Googles his name, news about the auction still comes up. And so he said that it continued to damage his reputation. Nakausad na nga siya, nakamove on na siya eh. And that this information should be removed from Google. Okay? So he went to the Court of Justice of the European Union. Okay? At ang sinabi niya ay, dapat burahin ako ng Google sa kanyang sa kanyang database. At that point, Spain had a data privacy law. Also, there was a directive on protection of personal data in the entire European Union. So this is what Mr. Costejo Gonzalez used to go up to the European Court for a ruling. In their decision, essentially, the European Court said that you have the right to erasure of data. And in his case, Google was told to remove the search results that came up about the auction of his property. It is his right, okay, na yung information na yun be confined to history. Nandun pa rin, no? Pero, it's just not indexed by the search engine. So, ang hirap naman, napapaburahin mo ng entirely, no? So, sabi ni Google, well, it happened, yes, but Google had to put it down dun sa SEO rankings. Okay. Now, this decision had really wide-reaching implications kasi at this time, no, the EU had been pushing for a new law, mas malaking batas on data privacy, of which the right to be forgotten was a key component. Okay? And precisely, the EU's argument was that old, inaccurate, or even, irrelevant data should be taken out of these search results if the person involved requests it. On another point now, take note that we're talking about an EU court and they were able to order, they were able to take jurisdiction over an American company. Okay? Ang naging effect nito was that the decision means that US firms, they can no longer hide behind servers, which are based in the US or anywhere else in the world. Okay? Your presence in other countries, no matter if your physical server is located elsewhere, as long as you offer services to consumers of that area, you must apply that kind of rule. Okay, so we have yet to see something of this sort in the Philippines, although I think a few weeks back, Senator Kiko Pangilinan filed a case in pleading Facebook. However, Facebook agreed to put down some posts, agreed to comply with the demands of Senator Pangilinan. So, medyo wala tayong makuhang clear clear decision or order from the court. Okay, next, let's have a Melvin versus Reed, which is related to the recommended movie. The Red Kimono. Okay. It's just a retelling of her story, no? So in this case, there was a prostitute who was previously tried for murder but acquitted. Okay. After that case, after that case, she completely turned her life around. Okay. And she married Mr. Melvin. Okay, so si Gabriel Melvin, tapos naging na siya, butihing may bahay. Alright? But years after, merong nakabalita, nakachismis ng nangyari sa kanya at gustong gawing pelikula. And without her consent, produced a film about her life. Okay? They used her maiden name, tapos in-advertise ito na true story, kung anong nangyari sa kanya. So she filed a complaint because she said that this was an invasion of her privacy. Okay. In the US, was it upheld? In this case, the court said that the complainant had the right to pursue and obtain happiness. However, no, with particular regard to her case, the problem was Mrs. Melvin failed to state a cause of action for the violation of the right to privacy. So, hindi yun yung pinush niya. Especially as the information that were taken came from the records of the trial, and therefore were in the public record, and they were no longer private. Kaya lang, syempre, nag-embellish din kasi yung filmmakers, so merong mga kwento tungkol sa nakaraang buhay niya. So, if it was about just the trial, the murder, okay pa. Pero ang problema, there was so much that the film told about her previous life. And the court said that uh, in the context of her reformation, tapos yung paggamit ng totoo niyang pangalan pa doon, it was a direct invasion of her inalienable right to pursue and obtain happiness. Okay ba yung right to obtain happiness? And the right to happiness, by its very nature, includes the right to live free from unwarranted or unnecessary attacks on character, social standing, or reputation. Let's just quickly go through CDs versus FR Publishing Corporation. Here we have William James CDs, who was a mathematical prodigy. So, magaling siya at para siyang pro-mill kid na kinover nung kabataan niya tungkol sa kanyang exceptional talents. Eventually, so nung lumaki na siya, tumanda na siya, parang naging normal na. He graduated from college at the age of 16. Okay. Pero after nun, parang wala na. He tried to live his life as unobtrusively as possible. However, the New Yorker nagkalkal naman at gusto nilang mag-publish ng isang article na quote-unquote, "Where are they now?" So, yun yung title. And here's the thing, the article on CDs was printed with the subtitle, so where are they now? So, tungkol sa kanya, ang subtitle, April Fool. Tapos yung pagkakasulat pa sa kanya, so maaga siyang nakilala. Tapos, medyo pino-point out na later, yung parang breakdown niya. And later on, yung pagtalikod ni CDs dun sa dati niyang buhay. So, later on kasi, he became just a clerk na hindi na nga gumagamit ng math. So, ang sabi na kahit na ganun pala kagaling, katalino, parang nauwi lang siya sa wala. And where CDs lived, he lived in a dirty room, tapos kinumentohan pa yung pagsasalita niya, yung mga personal interests niya, etc. And the closing sentence, kumbaga, is quoting CDs na with a grin that it's strange, sabi daw ni CDs, but you know, I was born on April Fool's Day. So, it was really offensive in a sense. But then, what's the issue? Kasi, ang sabi din naman ng magazine, did we print something untrue? Pero ang sabi ni CDs, you were merciless in the dissection of my private life. Yun yung masama. And there's great reader interest na amusing and instructive, pero napaka-ruthless naman, no, ng atake sa akin, sabi ni CDs. However, in this case, the court did not favor him. The court said that although there is parang bad treatment of one's public person, well, his previous life actually, or previous years as a child prodigy put him into the public spotlight. Therefore, his subsequent history, so parang pagkatapos, parang hinati yung buhay niya, after niyang makilala as a child prodigy, his subsequent history remained a matter of public concern and possessed considerable popular news interest. Okay? And nung sinilip din kasi ng court, yung parang magazine, parang sinasabi niya na unobjectionable naman. So, bottom line, I think the lesson that we learn from this case is that once you let the public into your life, then it could be, expect them to be there forever, to have an interest in you forever. So, dyan ka laging mag-iingat tungkol sa mga pa-fame o kaya mga pa-15 minutes of fame. Kasi baka mamaya sabihin ng tao, o bakit dati pinayagan niya kami, bakit ngayon hindi na? So, ingat-ingat lang at hinay-hinay tungkol sa mga ilalabas sa public. Okay, if we look at the Philippine context, it's clearly stated in our Data Privacy Act that data subjects may suspend, withdraw, or order the blocking, removal, or destruction, okay, of personal information. So, in a sense, clearly, we have the right to be forgotten under our domestic law. Another topic that we need to briefly talk about would be the right to privacy vis-a-vis national security, or actually, in general, this would be parang compelling government interests. And we can find this clearly in the writ of habeas corpus. Writ of habeas data. Sorry. The writ of habeas data is a special writ. Bottom line, you can ask the government for information that it has against you. And so, because this is the government that we are requiring to disclose information or data, then one of the defenses against submission of these data would be national security, state secrets, privileged communications, confidentiality of the source of information of media, etc. So, there is a particularity about the writ of habeas data, and we see that in the case of Lee versus Ilagan. Lee versus Ilagan actually is a sort of a private case. Actually, it is a private case. Between common law partners. So, kinakasama. Nung pumunta yung babae dun si doktora, dun sa condominium nung kinakasama niya, binuksan niya or kinuha niya yung digital camera ni Ilagan. Ngayon, nung nagka-confrontation sila, sabi ni Dr. Lee na, meron kang sex video with another woman in your camera. So, dininay niya, tapos sabi niya, si Lee to return the camera, etc. Initially, this was an issue, or this was a case for anti-violence against women and their children. So, VAUC. Pero, si Ilagan, yung kinakasama niya, ay isang pulis. Kaya parang sumingit yung konsepto ng writ of habeas data kasi nga, you can only invoke the writ of habeas data against the state or when there is state participation. Pero in this case, also, sabi kasi ni Ilagan na nag-threaten yung si Doktora na ipadala sa NAPOLCOM, which is a government agency, itong video na ito para makasuhan siya ng administrative complaint. So, parang pumapasok yung estado, although ang labo kasi dapat nga should be invoked against the state. So, precisely that was one of the reasons why the writ of habeas data, either the privilege or the writ itself, was not granted. Hindi kasi na-assert nung police, medyo no, nung police na that his right to privacy in life, liberty, or security was or would be violated through the dissemination of the sex video. So, sabi clearly dito sa case na to, ang petition for habeas data, it must show that there exists a connection or a nexus between the right to privacy on one hand and on the other hand, the right to life, liberty, or security. Bottom line, ang ano dito, hindi naman mamamatay or mawawala kasi EJK or enforced disappearance ang target or context ng habeas data. Hindi naman magkakaganon si policeman Ilagan kaya hindi ginrant yung writ of habeas data na hinihiling niya. Now, in the case of Gamboa versus Chan, we have a mayor of a town in Ilocos Norte and who sued or who claimed the writ of habeas data against police. Okay? The officer in charge of a commission, the Zenia Rosa Commission, which was formed to investigate the existence of private army groups. Okay? This was in the lead up to the May 2010 elections para wala na daw itong mga private armies. So si Mayor Gamboa, sabi niya, yung PNP sa Ilocos Norte, nag-surveillance sa kanya at saka sa mga amuyong niya. At parang pinaparatangan daw siya na merong private army. Yung ano din kasi, yung Zenerosa Commission was asked to comment kasi on a supposed report na maraming naglipa ng mga arms, tapos merong mga nahuli na mga members nitong private armies, etc. Tapos mukhang naiipit siya or napipinpoint siya. Tapos na convolute lang or nadagdagan ng gulo nung nag-broadcast itong ABS-CBN based on the Zenia Rosa report na isa siya sa mga konektado sa private army. So parang na-publicly tag siya as a leader of a private army or taga-pangalaga ng private army. So sabi ni Mayor Gamboa, you violated my right to privacy tapos siniraan niyo pa ako. At dapat ipakita sa akin nitong PNP Ilocos Norte kung ano ba tong mga pinaparatang nila sa akin and particularly criminal cases kung saan implicated daw siya as head of this parang private army nga. Now, in this case, sabi ng Supreme Court, yes, individuals have the right to privacy, but if there are competing or contrasting state objectives, the courts should carefully weigh between these two. And in this case, kahit may fundamental right si Mayor Gamboa, it must give way to an overriding state interest which was legitimate and compelling. That state interest was the investigation into the private armies and then ultimately the dismantling of private armies. So this was a legitimate state aim as enabled under the Zenia Rosa Commission. Sinabi din ng Supreme Court, they noted that the Zenia Rosa Commission was properly deputized the Armed Forces of the Philippines, NBI, Department of Justice, PNP, lahat ng law enforcement agencies to assist the Commission in the performance of its functions. So the investigation or the the surveillance by the police was, well, in the performance of its functions. On a particular matter, may issue kasi na parang bakit PNP yung nag-investigate or kumukuha ng information, tapos yung Zenia Rosa Commission yung nag-announce. So, again, there was a deputization. So, the Zenia Rosa Commission um, could validly deputize or talk to the PNP and other law enforcement agencies, even without prior communication to mayor or to any others. Okay, it's not a violation of your right to privacy kasi it's an inherent and crucial component of intelligence gathering investigation. Wala namang sasabihin sa, uy, inimbestigahan kita. So, ang sabi na lang, there are safeguards in place to make sure that the information collected maintain its integrity and accuracy. And sabi din ng court, there are other reliefs that are available to her to address this purported damage to her reputation. So, all in, sabi ng court, wala din namang maipakita itong si Gamboa na hinaharas kayo o kaya tumaas yung police surveillance because of the Zenia Rosa Commission. Well, manahimik ka na lang at intayin mo na lang yung pag-end nung or makuha yung findings ng commission. So, she was not granted the privilege of the writ of habeas corpus. Okay, the next case we have is that of Catherine Salukon, who filed a writ of habeas corpus against General Emmanuel Bautista. So, in Bautista versus Salukon, pag-akyat, nanalo kasi, this is my case actually, nanalo kami and we secured the privilege of the writ of habeas corpus against government officials. And then, the government appealed. So, General Bautista appealed. In this case, okay, Attorney Salukon, Attorney Cathy Salukon, previously was a POW lawyer, but she worked eventually full-time as a human rights lawyer, and she defended several political detainees, human rights defenders who were labeled, suspected to be members of the Communist Party and the New People's Army. Of course, things will take a turn when your clients are thought to be like that. And so she experienced harassment, surveillance, and at one time, no, after a meeting, she was in a meeting with a client and her paralegal. After they uh, split, so after they ended the meeting, so naghiwa-hiwalay na sila, her paralegal, during the meeting, her paralegal told her na parang under surveillance tayo. Later on, her paralegal, William Bugatti, who was likewise a human rights defender on his own, a member of Karapatan, he was killed. Okay? But the surveillance and the harassment continued, and to the extent that she felt that she would be next. One of her clients, actually, a police officer, whispered to her at one point na, ano mo, attorney, ikaw na next, nandun ka talaga sa OB. And so, there were so many things that that made her believe that she was the subject of surveillance and possible enforced disappearance, or, as in the case of her paralegal, extrajudicial killing. So we went to the Supreme Court asking for the writ of habeas corpus. Writ of amparo and writ of habeas data. And we were allowed. We were granted both the writ and the privilege of the writ. Ngayon, nag-apela pa itong mga, yung government. Ang sabi nila, first, of course, first line nila lagi would be denial, general denial. And then, they went to the Supreme Court on the question of whether we had substantial evidence to justify the issuance of the writ of amparo. In this case, the Supreme Court, with regard to that issue, said that we did present sufficient evidence already, even if I told you about the ano no, the parang binulong sa kanya about that information which came from an unnamed. So hindi namin mapangalanan itong police officer who told her that she was under surveillance or who confirmed that she was under surveillance. The court said even if it was in such character, uh, it still constituted sufficient evidence. Particularly as to the right to privacy, nilinaw lang dito ng Supreme Court na um, the writ of habeas data, it is an independent and summary remedy. Okay? Iba siya dun sa civil case or criminal case or etc. It actually precisely seeks to protect your right to control information kasi pinapalabas mo sa gobyerno for them to produce, to disclose to the court any and all facts, information, etc. Even if the Supreme Court is a government entity, this is not the violation of the right to privacy that is envisioned. Kaya, in this case, the information or the fact that she was under actual surveillance who looked like they were members of the military or police establishments was enough evidence to say that it's the state who was looking into the pattern of her movements, her activities, and thus she was entitled for the release, for the disclosure of all information held by the state against her. Okay, so now we'll talk about invasions of privacy. So, what if your privacy has been invaded? Okay, we have to go back to the context or the discussion of expectations of privacy versus the reasonableness of the intrusion. Okay. In Social Justice Society versus Dangerous Drugs Board, what was questioned here was random drug testing on certain categories. Okay. One category of which was private employees, of course, in private corporations, who were asked to undergo random drug testing. Sabi ng Supreme Court that this was constitutional, this was okay, because when you go to work, there is a reduced expectation of privacy. In fact, when you go to work, you submit so many things no to your employer with the okay, iba pa yung privacy ng data na ibibigay mo sa kanila, but you submit so many things to the employer for them to hire you. And it would be reasonable for them to ask you to undergo this drug test, lalo na random naman, no? Hindi naman suspetsado sa lahat. It was reasonable on the part of the employees to do that. Also, because this random drug testing was under the dangerous drugs law, so RA 9165, there was a compelling state interest that will be met by the invasion. Okay, ano lang, on a side note, what was prohibited? Okay, ano yung bawal na drug testing? One would be a drug testing that would be required of suspects of cases. Okay? Pag suspect ka na sa isang kaso, so ito daw yung mga nakasuhan na or may pending case before the prosecutor. Kapag may kaso ka na doon, tapos magda-drug test ka, pag nag-positive ka doon, madadagdagan. So, parang dito na papasok yung konsepto or the right against self-incrimination. So, you should not be subject to that kind of intrusion. Okay. So, that's the important part about SJS. Next, informational privacy. Okay. When you're a student, especially in a Catholic school, and you're in high school, so medyo mas iba yung standards of protection no, for high school students because of your age, well, of their age. um, there is a certain um, power or authority that the school can exercise over you. And harking back to our discussions about um, uh, disciplining students by the state, so they have the authority by the school, they have the authority. Now, in this case, several students um, took photos or had photos of themselves in parang half-half in their uniform or clearly na mukhang estudyante pa rin sila with bikini tops o kaya pang swimming. Kaya ang sabi ng mga madre, ang sabi ng Catholic school ito, sabi nila na hindi yun nakakaganda sa ng eskwelahan kaya hindi sila pinagmamartsa. Yung relevant sa atin dito would be the privacy expectations on Facebook. Kasi yung mga pictures ng mga bata, in-upload sa Facebook. Okay. What would be your reasonable expectation of privacy on an OSN? Yung pa yung tawag no, online social network. Ang sabi ng Supreme Court, ni-recognize niya that there would be tools in these or in these platforms that would allow you to control privacy settings. And in this case, even if parang friends only yung setting ng pictures, yung videos, still, it was meant to be shared to friends. And um, it would eventually be impossible almost to stop the flow of or the making public of this information. Lalo na naka-share sa friends. I want you to just briefly see this video from an episode of Ipaglaban Mo, which was precisely about this case.
Graduate na rin tayo. Let's try it on.
Sa mundong trending ang pasaway, kinabukasan nila ang nakataya.
Ano to? That is certainly not something that you should post online. These are grounds for expulsion.
Sobra naman kayo.
Gusto ko may magpayo sa'yo! Nagpapakahirap ako sa trabaho para mabigyan kita ng magandang kinabukasan. Sorry po.
Hindi makakamarcha ang mga anak ninyo.
Hindi pa ba sapat yung kahihiyan na dala-dala ng mga bata? Bakit mo pinagkakait sa kanila kinabukasan nila?
Goofy sa direksyon ni Theodore Boborol.
So that's the case of Vivares versus St. Teresa's College. Now, let's go into briefly the National Privacy Commission. So, as we earlier introduced, it's an independent body under the Data Privacy Act. Now, it possesses quasi-judicial powers. What do we mean by that? So, judicial power is when you interpret the law. It's like you're a court. In this case, the National Privacy Commission is an executive agency, but it can interpret the law. Okay? So, if there are data breaches, pwede siyang may parusahan. Pwede niyang sabihin na, ito data breach, ito hindi. Okay? That's what we mean when you interpret the law. So, in essence, it is the agency that requires compliance with all institutions, all agencies, private and public, with the Data Privacy Act. At kaya niyang mag-utos na, sige, ayusin niyo yan. I-check niyo kung ano ang problema. Check natin kung ano yung mali dito sa sistema niyo. And they can demand the information from these entities. Ano ang sistema niyo sa pagpapatupad nito? Ano ang ginawa niyo? At paano niyo ito susolusyonan? Just a few points from recent developments or recent opinion or advisories from the National Privacy Commission. First, talking about health declaration forms or yung log sheets kapag papasok ka ng any or contact tracing forms, okay? It should not be in matrix form actually, yun yung sabi nila. Yung makikita mo yung lahat ng information nung before you. Okay? Kaya mas preferred ngayon yung sheets. So, isa-isa mong fill upan, ihuhulog mo sa Dropbox. Of course, may issue ngayon tungkol sa smishing kasi posibleng isa yun daw sa paraan kung bakit nakuha ng mga tao yung numbers ng napakaraming iba pang tao. Okay. Next, online sellers. Okay, so pag bibili ka, a few online sellers who have already been sanctioned would be Jollibee and Wendy's. So sa website nila, nagkaroon ng data breaches. NPC had to step in and they ordered the suspension of these websites. So in these cases na na-address, but of course, we have to be vigilant as to all other platforms where we buy things. So same goes for Instagram sellers and all other types of sellers, whether big or small. Okay. Next, for online classes, one of the advice as sent out by the NPC would be with regard to backgrounds. In fact, as much as possible daw, don't show the private spaces of learners. And as we disclosed on the first day of class, hindi pala, as we disclosed, as I discussed with you, as I shared with you, anything that we discuss in class, pictures, videos, audio, will remain within the class unless with the explicit consent of all others who are featured in these discussions. So if we will be posting screenshots of our class or anything, and then we need the consent of everybody. And we close off our discussion with that. And I will see you next time for our last module on copyright law. So thank you very much.